Ma'am?
I'm sorry. I'm just trying to get my stuff situated so it's ready here.
Take a seat
I have a
in
question.
this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit
same
down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges
I object.
filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea. You're
Okay, so
entering
you
that
tell
plea.
me how you would like the plea: guilty, not guilty, or no contest.
First, I have to correct the standing, which is I am not the ens legis non degear. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case. I have sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial, and we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case, but then because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Involuntary can't be violated, basically, is what it means. So I have the right to a jury by trial.
No, you don't.
Of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they're going to give you a trial date. Okay? So
then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis non degear. I told
I
you that.
don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So,
great.
Yeah.
So
ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail, and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
you are not the beneficiary, and nor am I the trustee.
Yes.
Yeah, that's just not how it works, man.
It
Not
is.
how it works. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Step to your right to the T. When the light comes on, sign. Ready, state your name.
For the record, could you state your name, Judge? I can barely hear you talk. Could you state your name?
My name is Brantley Clark.
And your title, please.
I'm a circuit judge. What's your name?
I am Eden Bay, a sovereign living man.
No, sir, you're not. What's your name?
My name is Eden Bay. I'm a sovereign living man of the authorized.
No, sir, I'm not accepting that. Is this Douglas Young?
I'm the authorized representative of Douglas Young, created by the public trust of the state of Florida.
I'm asking.
State of Florida is a public trust and the grantor. I'm the beneficiary and executor. You are the trustee. There's only one position left.
Go ahead and take him out, and I'll go ahead and set his bond while he's out. What's he in jail for?
You had him Monday. You had him Monday on a trust. Yeah, you did the same thing Monday.
All right, I'm gonna set, he's got fraudulent services. I'm gonna find there's probable cause. I'll set a $5,000 bond on that charge. A $5,000 on the perjury and not official proceeding. His next court date is December 12th. And let's see, I don't think he was asking for the public defender, so I want to appoint him at this time.
That's 5 and 1 because it broke up.
Pardon?
Was it 5 and 1 or a total of 10?
Yes, ma'am. 5,000 on the felony and 1,000 on the misdemeanor.
Yes, sir. Thank you.
I believe I saw recently there was a eval set up and they were unable to reach him to participate in that evaluation.
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
I don't recall.
You participated on Zoom on April 8th, and we discussed that your evaluation was calendared for the 24th of April.
Was there anything signed for confirmation?
Well, your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we were unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
I'll tell you in just a moment. So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
That's an assumption and presumption. I'm not nobody's defendant. I'm authorized representative of that account.
Okay, so Mr. Richard, the thing is, if you cannot participate out of custody, the court may have to set bail and have you placed in custody to get this evaluation accomplished. So when you are informed of the appointments and then you choose not to appear, the court interprets that as a willful violation.
Under what law are you saying that I could? What charges? What are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this point, we need to.
I don't disagree with none of the facts. I said, what was the date?
The date of the driving? Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file.
June 4th, 2022, Your Honor, is the charge date.
Thank you.
Okay, and have I been charged with anything?
Yes.
Then what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring to attain to that?
Those are the criminal charges. You also were cited for not having insurance.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to, I don't understand. So can you explain to me how
we've explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain to whatever you're asking, because I have questions and you're not answering them. Are you willfully not answering any questions?
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action. My Sixth Amendment right. I need to know these things before we can move further. Are you refusing to tell me?
I didn't quite hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the 3rd degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down, and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions, and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree to meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody. so that they can
So
talk to you
basically,
while
you're
you're
telling
in
me you're
jail.
refusing to answer me. You're refusing to answer any questions? That's what you're saying? Because I just have questions.
All right, does
Hello?
not. Mr. Richard? We've answered your questions. We're going to proceed at this point. I'm going to.
I didn't even answer. I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant? Can you answer that question, please?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation
If you
of
took
the
an oath,
RCW and the Lake
if
Forest
you took
Park
an oath, then
Municipal Code.
why are you enforcing statutes if you took an oath to uphold the Constitution?
I know you don't think that it applies to you, but it does. So I
didn't say it didn't apply to me.
I'm going to set bail in this matter at
You're making
$10,000.
assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions, and you're just going around me. Obfuscation is
I'm
a
going
big
to
thing
set
now.
bail at $10,000, and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice, so I didn't refuse anything.
I know you were put on notice at our last hearing, so that's on the record. So
What's
I
on the
know that
record?
to be false, Mr. Richard. So that
So
is
everything that I asked you, am I wrong? Is that
yes,
what you're saying?
yes, you're wrong. So we're
I'm
going to
wrong.
end this, and we are done on this matter. Mr. Parent, if he does reach out to you and something can be arranged for them, but right now the doctors have tried twice to contact you, and you've taken a spot that would have been available to someone else. So we need to progress this matter, and that bail will be set, and we'll continue with an in-custody hearing date when you are booked. A warrant will be issued.
And upon the booking, Your Honor, would the court consider amending the competency evaluation order to reflect in custody, just to kind of expedite that process?
Yes.
For the record, the judge is willingly going against public policy. So on here and there, you're held liable for everything you do from here on out.
All right. Thank you, Mr. Richard.
For the record.
I also find that you're in contempt of court for failing to appear for your jury trial on Wednesday. You have some misinformed, misguided notion that the laws of the state of Michigan don't apply to you. People refer to this as sovereign citizen, but that isn't what it is. There's no sovereign in it. I call it willingly misinformed defendants. There's no sovereign about it. And you wasted a whole bunch of our time, the prosecutor's time, filed a bunch of documents that didn't mean anything. You were always respectful, but she made this very generous plea offer several times, but you wanted to represent yourself. You wanted to have a jury trial. The irony of this is that you demanded your rights as a citizen in the state of Michigan to be presumed to be innocent, to have an attorney appointed, and to have a jury of your peers. If you got a jury summons, you wouldn't have shown up. You would have said, I'm a sovereign and you can't dictate what I have to do as a citizen of the state of Michigan. But you're okay if you drag in 30 other people who took the day off work, who were nervous the night before. They came in here and sat around here for 45 minutes waiting for you to show up. And you wouldn't have shown up if you had been a juror. It cost the county $565 in jury fees, and it cost the jurors probably thousands of dollars to come in here for your foolish request. So the contempt was committed in my presence.
Now, you providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. That's you're representing yourself. You have to know those rules. If you don't, you're going to mess up.
I understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. I mean, he's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for a, don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December?
December 19th.
December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen, all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you
No
December
problem.
19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one. I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th.
It doesn't matter. You're obviously here legally. You were born a citizen. You may have.
I have changed my nationality is what I've done.
Where's your passport from?
It's issued by the government of the United States of America. It's not a blue passport. It's a different colored passport than that. Mr. Marvin says that there's no such thing as that, and that's fine if he wants to choose to do that. But I have had no issue. I have had no issue from anyone or anything using that. Granted, I have not gone to the country with that yet. I have not had the means to do so.
Yeah, good luck.
But
Go on,
either way,
good luck trying to get back in. My
Right.
advice is don't do that.
Mhm.
You'll be a man with no country. So
Well,
don't
I-
leave the country, but you're here.
Mhm. Yeah, like I said, according to the Universal Declaration of Human Rights, I have a right to change my nationality. And the Crown Corporation here is trying to deny me that nationality, which really falls under a religious persecution issue here, because I don't want to have any more dealings with the Crown Corporation. And so
I don't know what universe you're from, but there is no Crown Corporation. This is the state of Michigan. And in the state of Michigan, you have to have a driver's license. You may have one.
Hey, Mr. Marty.
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamil Marty, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my Fourth and Fifth Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my Fifth Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr. Cromartie, what are you asking me today? I'm gonna give you one
No,
more
I
chance.
don't need him on my case.
Okay, are you at, listen, what are you asking me to do?
Or this one right here. Both them two right there. I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do?
Continue my trial.
No, sir, motion denied. What are you asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right now, you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself or are you gonna hire another attorney?
I'd rather represent myself to get an attorney.
You already sworn in, so state your name again.
Jamel Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week, is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay. Do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court, is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that, is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest and that would settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
There's
correct?
a lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court. Is that correct?
I'm not gonna say I'm being truthful.
When you
I
said,
don't understand.
you don't understand.
You got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't understand because there's some shit.
So you
that's
don't
going on.
you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell.
Okay. And you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did.
do what I can that I've been trying to do.
Do you understand you'd have to do
I
everything?
do better than him.
Listen to me. If you want to represent yourself, you got to answer these questions. If not, I can't allow you to represent yourself. So
I ain't trying to make a fool of myself, but Your Honor, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're gonna pick a jury Monday morning. I'm not continuing the case. And you're gonna try the case next week if you represent yourself.
Okay.
And you read and write.
I'm gonna learn.
You don't have time to learn. So you can barely read and write. Is that correct? You don't understand about the plea offer. Do you understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm gonna find that you're not competent to represent yourself. Mr. Salim will stay on his case. Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury.
All right.
All I have is what they provided to me.
I didn't send you a copy of what I had sent them when I tendered the payment and they sent it back.
But ma'am, I don't know what you mean by payment. He says it wasn't a check. What was it?
Okay, it was a negotiable instrument that could have been used as a check, but it was.
Well, what was behind it? What kind of negotiable instrument?
Well, it was connected to the treasury.
May I approach?
The treasury? Like the US Treasury?
Well, the Michigan Treasury, not the big one.
I would ask, is this what you're?
Yeah, no, it's perfect.
I'm holding in my hand a document that says this is a non-cash item, not a check on the top. And may I approach, Your Honor, so you can take a look? This is what we're discussing.
Okay. I don't know what this is. It's got some numbers on it.
It's not drawn from a bank. It's not a check.
It was gonna be drawn
Payable through Tracy Moore and done in good faith. That's her address. It says it's paid to HP foreclosure. And then it has the United States Treasury, Pennsylvania Avenue, real property for set off an adjustment. And it's signed by Miss Moore without recourse. It says void where prohibited. Non-cash item per 12 CFR subsection 229.2 U1, 2, and 4. And it says here, this is a non-cash item as defined by that section I just said of CFR and issued according to 12 CFR 229.2 K3 and 4. Non-cash item is an item that would otherwise be a check, except that a passbook, certification, or other document is attached or is accompanied by special instructions with a request for special advice on payment or dishonor, or it has not been pre-printed or post-encoded in magnetic ink with the routing number of the paying bank.
I believe, in other words, it's a piece of paper. It's not.
A negotiable demand draft by the U.S. Treasury, a demand draft drawn on the state government or unit of general local government that's not payable through a bank. Okay, I mean, you just, I don't know what this is, but you said that no money accompanied this. So, and this was, I don't know when it was dated, June 10th.
Mm-hmm. It was within the time period.
But
they held it and then.
Well, let me ask you this. Where were they supposed to cash this?
Well, they would have sent everything to the Treasury. It was all the original, it was everything. All they had to do was just send it to the Treasury.
And the Treasury has $153,749.97 that belongs to you, that then they were just gonna pay to them.
Yes.
Okay. I don't see how that could happen.
Well, we wouldn't know because they sent it back.
Because my client can't do anything with that.
Well, when I called, why didn't they say that? They held it for 2 weeks.
They don't need to do anything with that. It's not a payment. If there was a payment, they would have to accept that payment. There was no payment.
Your Honor, Ms. Lewis is present. She does not wish to respond under this name. But she is present. I don't know if Your Honor can see her.
So what name today does Ms. Lewis wish to respond under? Ms. Lewis and I kind of know each other.
I resent that statement made by the court. It is my natural name. I was adopted and then I incorporated my name. I am sorry, Mr. Sampson. I do not disrespect you and I appreciate it if you did not disrespect my name.
Okay, so here's what we'll do. All right. Before this gets too far afield. I know that this is the individual that I know to be Octavia Lewis, as we call her here. So what do you want to do in this case, Ms. White?
Yes, I was appointed to this case. I had the opportunity to speak to Ms. Lewis this morning. We are asking for an adjournment so that we can get discovery.
Without objection, probable cause conference will be adjourned. Let's just do October 5th. October 5th, 2023.
I'm through.
9 a.m. Bond continued. Thank you.
Thank you.
You're disrespectful.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone. And the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay, I yield.
Very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me, I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you've got COVID. I want you here, when's our last block? 3 o'clock today. Wear a mask if you're gonna represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can.
Done. Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. Would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demurrer. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not, they are virtually the same thing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have
Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
I wish to finish before I answer your questions. I will answer your questions. I want to finish exercising my First Amendment right, freedom of speech, and continue what I was saying. Now, again, I was
Sir, you are to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court.
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now, Mr. Allen, if you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me? No, not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. Let's start there.
Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean, I'm confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
Drawing my name from the record on that one. Thank you.
I know. How do you
record? I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right. So you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right. Well, I'm glad you're breathing. So
Well, what I'm understanding is that the courts is a private
So,
for-profit.
Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you.
There were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel, defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Ms. Pugh, don't
with my
speak over me.
incarceration, respectfully, Your Honor, with my incarceration being
Ms.
filed-
Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful.
So the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or sophisticated trust action. And so I'm here sui juris in pro persona. You know what that means. And so we can
I
prove
don't know what it means because it's nonsense, but no.
and my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record.
Wanted to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being. Okay.
I'm my own attorney. You're your own attorney. You're an attorney registered by the state of Michigan. Registered. You don't have license to practice law, and you've been practicing law over the bench. You say I have been? Would you like to litigate against me? I'm not litigating anything against you. Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today. Okay.
I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me, the caps. I'm not that caps.
So who gave you the last name Little? Your mother?
The government did.
So your mother didn't give you that last name?
The government gave it to me.
She had to tell the government, didn't she?
The government. She was an agent of the state.
She was an agent of the state? All right.
So I object to what she just said about I made some self-incriminating statements. That's not true because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no.
What is the name of the crime?
I told you it's driving while license suspended, 3rd degree, and operating a vehicle without an ignition interlock device.
Is there any injured parties? Is there somebody willing to go on the stand and say that I actually committed a crime? Who has a claim against me? Like that's what I'm trying to figure out. I'm trying to settle the matter. I'm not arguing the facts. I'm just trying to take care of this and
we cannot proceed while your ability to understand the nature of the
What do you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff.
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant? Can you answer that question, please?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation of the RCW and the Lake Forest Park Municipal Code.
Why are you enforcing statutes if you took an oath to uphold the Constitution?
I know you don't think that it applies to you, but it does.
Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
Put your mic. All right, this is the morning we would be beginning landlord-tenant matters here in a bit. But we've got an unscheduled matter. Mr. Justin Michael Aiken is here. File number 222036 alleges no insurance under the insurance code. File 222037 ST alleges driving suspended first offense and improper plate. Those are alleged to have occurred on October 18th of last year. Also, the case is file 2240 SM, alleges no insurance and driving suspended on January 1st of 2023. Mr. Aiken is here. This matter was set for jury trial on Wednesday, May 24th. Deborah Davis is here with us from the prosecuting attorney's office. She had been managing these cases, but she was obligated to try another case in the circuit court on Wednesday, very important case. And Casey Johnson was assigned then to handle this case, and he was here Wednesday, ready to proceed. We had prepared the jury instructions. We had 30 jurors here, and we were prepared to go to jury trial on the October 18th case. In your case, you had steadfastly maintained your I'm not sure, lack of responsibility. I won't say innocence, but and expressly indicated you did not want to have an attorney to represent you. And you also steadfastly remained in your request for a jury trial. And we were here, we had 30 jurors who all took the day off. And we were prepared and you didn't show up. And so I issued a bench warrant for your arrest. And I said on the live stream that if anybody knows Mr. Aiken, have him come turn himself in. And that was Wednesday. And here it is Friday morning, and here you are. Mr. Aiken, what's your position here?
Well, Your Honor, I'd like to apologize to you and everybody that was here for the trial. And I got scared that day, and I apologize to everybody for not being here. And if we could work, you know, some kind of financial plan, something of that sort, or whatever you feel necessary needs to be done, I'll get done. I'll take responsibility.
Mr. Aiken, have you paid your ticket in Coldwater?
I'm actually been trying to work on that.
Okay, so once that's done, you'll be able to get your license from the Secretary of State again?
Yes.
Okay.
And I plan on getting insurance as well on my vehicle.
Very good.
Well, we still have these two cases, which were set for jury trial. And what do you wish to do with those? You wish me to reset them? Or is there some?
Before you make that decision, the offer of allowing another to violate the motor vehicle code in each of those, which is the offense that doesn't carry any points on your license, so it wouldn't prevent you from getting your license once you pay off your cold water ticket and probably a reinstatement fee to the Secretary of State. If you pled to account in each of the files, we would dismiss the remainder.
All right, that was the original offer, and she bent over backwards to make it. So let me repeat what it is. You're charged with two separate incidents, one in October of 22 and one in January of 23. Driving suspended and having no insurance. No insurance is punishable by up to a year in jail. It carries a minimum fine of $200, a maximum fine of $500. It requires you to be fingerprinted, and it doesn't have a restriction. The driving suspended charge requires that your license be suspended. It carries 2 points, fine of up to $500 and up to 93 days in jail. The prosecutor is agreeing to dismiss all of that, plus the plate violation, for 2 pleas to allowing another to violate the motor vehicle code. Allowing another to violate the motor vehicle code is sort of a legal fiction. The other that it is allowing to violate the code is yourself. But it carries no points. It doesn't get abstracted to your driver's license and won't affect your ability to keep or maintain your license. Ms. Davis had made that offer at least twice before and you declined it. Are you willing to accept that at this point?
I'm willing to accept that, Your Honor.
All right. Did anybody promise you anything to get you to plead to this?
No.
Diana, you need Debbie?
I just need a signature. Thank you, Judge.
Sure.
And let me know. Sorry.
You can keep that.
Am I back?
No, actually, no, I need it back. I just thought you might need a pen.
I don't typically work paperless, but that's an amended information or amended.
All right, Mr. Aiken, let's talk about that. Other than what Deborah said and what I just explained to you, did anybody promise you anything to get you to plead to this?
No. It was all me just wanting to get this taken care of and resolved.
All right, anybody threaten you?
No, sir.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, I agree.
If you had a trial, you would have the right to be represented by an attorney. All you gotta do is ask me, but you've been adamant throughout that you did not want to have an attorney to represent you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so that you could be questioned under oath. You would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
2230236. All right, were you driving a car in Constantine on October 18th of 2022?
I was driving.
Traveling. Well, did you not have insurance on the vehicle at that time?
I did not. I just purchased that vehicle within a week during that time.
It was a truck.
Yeah, it was a truck.
All right. I'm going to order a $75 crime victims' rights fee, $50 state minimum fee, $125. I'm going to give you until July 1st. All right, that takes care of the first case. In the second case. Oops. That's 2, 3. 40. An order 10 days jail, credit 0, leaving 10 days to serve. Same thing, $125, due by July 1st of 23. I also find that you're in contempt of court for failing to appear for your jury trial on Wednesday. You have some misinformed, misguided notion that the laws of the state of Michigan don't apply to you. People refer to this as sovereign citizen, but that isn't what it is. There's no sovereign in it. I call it willingly misinformed defendants. There's no sovereign about it. And you wasted a whole bunch of our time, the prosecutor's time, filed a bunch of documents that didn't mean anything. You were always respectful, but she made this very generous plea offer several times, but you wanted to represent yourself. You wanted to have a jury trial. The irony of this is that you demanded your rights as a citizen in the state of Michigan to be presumed to be innocent, to have an attorney appointed, and to have a jury of your peers. If you got a jury summons, you wouldn't have shown up. You would have said, I'm a sovereign and you can't dictate what I have to do as a citizen of the state of Michigan, but you're okay if you drag in 30 other people who took the day off work, who were nervous the night before. They came in here and sat around here for 45 minutes waiting for you to show up. And you wouldn't have shown up if you had been a juror. It cost the county $565. in jury fees, and it costs the jurors probably thousands of dollars to come in here for your foolish request. So the contempt was committed in my presence. I'm gonna do it in the other case, 232036. You had been respectful, but that's disrespectful to me, to the prosecutor, and to all those private citizens that came in here because of your whimsical, and I don't even know if they were sincere beliefs. Whoever sold you on this foolishness is cynical. They don't even believe it. I don't know whether you believe it or you're just like messing with the system. But when you involve 30 or 35 of your common citizens who get dragged into this, it's no longer polite or respectful. And you could have had a trial. They would have been here. It would have taken Mr. Johnson about a half an hour to put in the proofs. I also understand, Deborah, he may have 4 or 5 warrants out of Elkhart County, Indiana, and a non-support warrant. So I believe he's also wanted in Indiana. And we'll explore that. For the contempt, I order 30 days, credit 0, concurrent with the 10 days I gave you on the other case. And the cost of the juror to the county
It appears there's 5 separate warrants out of Elkhart for same charge each time: invasion of privacy, violating protective order.
And that's protection order expired as of January of this.
I don't know, but there's
They're
apparently
all
warrants
from
for your arrest.
2022. They've been pending. I didn't realize that those were pending when we were doing all this other stuff. I can contact Elkhart County.
Yes. Now, darn it. It was Wednesday. She sent me that. Cost was $524.05. So you'll $525 restitution for the cost of the jury. You got a sweet deal from Miss Davis. My advice to you is you get a driver's license like everybody else, like all those jurors that came in here to hear your case, and you stop driving. Now, did somebody bring you here today?
Yeah.
You got 10 days on the driving charge. You weren't traveling, you were driving. You got 30 days for poking me in the eye with a sharp stick by not showing up for a jury. And you've got pending warrants from the state of Indiana and possibly others from Michigan. You're going to be in jail for a while, so I'm going to change that due date to August 1st, not July 1st. On both of those. All right, you can go to the court officer.
Thank you.
You could have made things a whole lot easier. You can have those envelopes, Frank. Thank you, Deborah.
Thank you, Your Honor.
What's your name?
I'm here representing Brian Musgrove.
You're Brian Musgrove?
I'm here representing.
I have no idea what that means, so why don't you come up to the podium?
I tried to,
Nope, yeah, stand in front of the thing. So what is your name?
Brian Joseph Musgrove.
Okay, are you an attorney? What's your P number?
I'm not an attorney.
So then you can't represent Brian Musgrove. So you are a defendant, correct?
I'm an ex-executor on that estate.
Okay, so none of that is valid or legal. So you have an attorney?
He's not doing nothing for me.
Okay, that was my question. Do you have an attorney? Yes or no?
I have, yeah, he was supposed to be representing me, but
So you have Michael Dagger Margosian. Okay, so he's your attorney. Okay, so go have a seat. When Mr. Dagger Margosian gets here, I'll call your case, okay? So, Mr. Musgrove, you want to come up to the podium, please? This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger Margosian might, oh, there he is. So, Mr. Dagger Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you. So.
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have all
in order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case.
The victim would be the company.
You are charged.
I can't face.
Actually, just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. that being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal, industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years. You're charged in count 2 with using a computer to commit a crime. To facilitate the charge in count 1, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can. Yes,
They
they
can?
can. Yes, they
Okay.
can. So I have $189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes, they
they're-
can. Yes,
they're
you
going
can be
by
charged.
Everything,
You
all the
can't-
laws and statutes that you guys go by
Are
for
legal.
corporations. They're for
Still a crime. Still a crime.
But I'm not
Still a
a fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid. It's
Okay.
not legal.
right.
So do you want to represent yourself or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musgrove?
Yes, Judge.
All right, so Mr. Musgrove, have a seat on that bench right behind you. And then Miss Adams will give my bailiff a notice of hearing, and my bailiff will provide that notice of hearing to you. Mr. Dagger Margosian, did you have any other matters in my court this morning?
Yes, Your
We're here for a pretrial today, and apparently Mr. Shaw refused to sign his advice of rights form.
I didn't refuse to sign anything.
Oh, that's what the note on my file says.
They think that's an alias. They trying to say my they trying to say my real name Adams and destroy Yolanda Adams, but Ice-T little brother, my daddy, and I get his last name, ma'am. I did not refuse to sign anything. They trying to make me put Adams on there.
All right. Well, thank you for that information, sir.
Yeah.
Your Honor, I'm not sure if we can proceed without that. The offer is a civil infraction to impeding traffic, I believe, Mr. Barnett. Is that correct?
That is correct.
So, sir, they're indicating that they're offering you an impeding traffic, which is a civil infraction. That's a fines and costs matter, okay. The fine will be $180. Are you willing to admit responsibility to the impeding traffic, sir?
I ain't paying it. They can give me jail time.
Well, you can't get jail time for.
Oh, I just owe it. I owe it to them. They get it when they get it.
Ms. Mueller?
Sorry, Your Honor. I did advise Mr. Shaw that it would be a fines and costs matter when we were in a breakout room. I don't know if maybe we could ask for one more breakout room. That would be helpful to Mr. Shaw. Or if not, we may have to adjourn the matter.
I don't think it's gonna make much of a difference with Mr. Shaw that you have another breakout room, to be honest.
You
but
know it don't.
I will give you that. Okay, I'll pass this for a moment.
Thank you, Your Honor.
The court will recall the matter of Jermaine Shaw, case number 23W004577.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Mr. Shaw. Mr. Shaw, could you have the jail unmute you again and state your name for the record, please?
You need to have them unmute you, sir. There you go. Now, can you state your name?
Jermaine Shaw. Shawshank Redemption. I have Ice-T little brother's last name.
Thank you. Ms. Munger.
Your Honor, I'd ask for an adjournment here. Mr. Shaw did indicate to me at the end that he would like to just plead to the misdemeanor. He believes he's going to be serving some time, but I'd like a chance to speak with his felony attorney and maybe see what direction they're headed with that before I have him plead to anything on this.
It makes sense. I will adjourn this. Any
Oh, no objection. Yeah, no objection to that.
We'll adjourn it. When is his next court date on the felony? Because this case is not holding him in custody. Do you know your next court date, Mr. Shaw?
I think it's the 5th. I think I got one on the 5th and the 7th.
Okay.
The 5th sounds. It looks like March 5th. That's correct.
And that's a what, pretrial?
Yes.
Right.
At 1:30.
I'll put it over to March 13th, 2024 at 9 a.m. We'll see you then, okay, sir?
Yeah.
Thank you.
Jonathan Schuster. For the record, Abigail, this man was never appointed to me on my behalf. Like I told him the very first time I've ever met him, I'm here sui juris in propria persona. I reserve all rights. I, Jonathan - Troy Fayekoleasamagriatoa Colin Schuster, comma beneficiary and sovereign, and here for fraud, menace, and duress. Fiduciary Abigail. This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is a commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is assessed a case trust action, which you are a real party in interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen, American national, by way of American Samoa. I'm beneficiary. I am here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me. Like
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay. Yes,
So the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or certificate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you, You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
gonna represent me. I can present myself, as I
Okay.
said.
So you want,
initially.
so you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you, I'm here sui juris and propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial and suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further. Because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position. Because it
it's
is
not.
on the courts.
And I'm also not gonna argue with you.
There's no
So
arguing.
I'm gonna have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're gonna come back to court on July 1st.
That date doesn't work
Why doesn't it work for you?
because I'm a man. I have things to do. I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're gonna come back on July 1st at 9 AM. If you don't come back on July
Are
1st,
you threatening me now?
I'm telling you, there's gonna be a bench warrant issued if you don't show
You're
up. So
threatening me now.
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you like
gonna,
to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not gonna do that today. So July 1st, 9 AM, back in this courtroom.
Abigail? What's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for
You
this week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail?
I am telling you
No,
your
I'm telling
options.
you, this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature
separate
here.
trust action.
Signature
You're
here,
trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
you
done.
can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more so
giving you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
So for the record,
For the
the
record.
defendant's choosing to leave without his paperwork. He is expected to be back in court July 1st at 9 AM.